All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelée à exercer la fonction résiduelle de tribunaux pénaux est ouverte. Please be seated.
Good afternoon, everyone. I'm very pleased to welcome everyone back to the courtroom for the first hearing in 2025, which I'm conducting from the mechanism premises in The Hague. I'm joined today by Judge Elbaz and Judge de Guzman, who are participating by way of video conference link. I note that while this hearing should have been held at the beginning of April, the parties agreed on an exceptional basis that it may instead take place at the beginning of May. I thank the parties for their flexibility in this regard. Mr. Kabuga is also appearing today via video conference link, and it has been confirmed to me that he is receiving interpretation in Kinyarwanda. I will start the proceedings with the appearances for the parties. Ms. Begg, would you please identify who is representing the prosecution today?
Thank you, Your Honor. I'm joined today in the courtroom by Mr. Kevin Hughes, the prosecution chief of staff, by Maria Yakusheva, a trial attorney on our team, and by Dennis Turahan, our case manager. And we are joined by video conference link with our colleagues in Arusha, the senior trial attorneys on this case, Mr. Rashid Rashid and Mr. Rupert Elderkin.
Thank you, Ms. Begg. Now, Maître Altit, the defense team today.
Bonjour, Monsieur le Président. Bonjour, Madame. Bonjour, Monsieur.
Good afternoon, Your Honor. Good afternoon, ladies and gentlemen. I am joined by Madame Elatit, and I am Manuel Altit, and I represent Mr. Kabuga. Thank you.
Thank you, Maître Altit. The purpose of today's status conference is twofold. It provides the parties with an opportunity to raise matters concerning Mr. Kabuga's health and detention, and it allows the defence to identify the progress it has made in locating a willing state of provisional release for Mr. Kabuga. The trial chamber remains of the view that these hearings, which are judicially ordered to take place every 120 days pursuant to Rule 69, are not only essential for its expeditious consideration of the appropriate modalities and conditions for Mr. Kabuga's release, in line with the instruction from the appeals chamber, but also afford the public important updates on matters that are generally addressed on a confidential basis. I also recall that on the 17th of December, the trial chamber amended the defence progress reporting regime, in which it instructed the defence to file a report on the progress it has made in identifying an appropriate state of provisional release as soon as possible, should there be any material developments, as opposed to filing a report every 2 weeks. Since that order was issued, the defence has not filed any updates with the trial chamber. In preparation for today's hearing, I held a case management meeting yesterday afternoon with the parties and the registry to focus today's discussion. So I move from that introduction to a procedural update. Prior to hearing from the parties, I will briefly update the public on the procedural developments since our last status conference, in which I provided general information on preliminary litigation with respect to the issue of whether Rwanda, Mr. Kabuga's country of nationality, is an appropriate state of release for him. This litigation is ongoing. On 16th December 2024, the trial chamber issued a confidential order requesting the appointment of an expert to specifically address the risks to Mr. Kabuga's physical and mental health that would be associated with transporting him by air. This expert was appointed by the registrar on 29th January of this year. On 22nd April, the expert filed his report and concluded that from an official point of view, Mr. Kabuga could not be declared generally fit to fly. In addition, the registrar filed the 6th monitoring report on 18th February, in which the panel of court-appointed independent experts provided their most recent opinion, confirming their previous views that Mr. Kabuga remains unfit to stand trial and to travel. With respect to the recovery of legal aid funds provided by the mechanism, I recall that the trial chamber issued a confidential order for contribution in October 2024. In this order, the trial chamber requested that the relevant state, which is located in Europe, should assist the mechanism in recovering the funds attributed to Mr. Kabuga by taking the necessary steps to unfreeze the amount required to cover current and any future legal costs of his legal representation before the mechanism. I further recall that the registrar filed a confidential submission the following month, updating the trial chamber on the implementation of the order for contribution, as well as identifying possible next steps. Between 30th January and 14th February, internal communications have also taken place directly with the registry on this issue. In these communications, I have again reiterated that the recovery of the legal aid funds represents a high priority for this institution, and the registrar has assured me of his office's commitment to the implementation of the order for contribution. On 4th March, the registrar filed a confidential note verbal from the relevant state authority. This note verbal indicated that the relevant state authority is conducting a thorough and coordinated analysis of the order for contribution, and in this regard requested additional information and filings to complete its analysis. On 29th April, the registrar sent a note verbal in response to the relevant state authority, which included 8 of 10 filings requested by the state. On that same day, the registrar also filed a confidential submission pursuant to Rule 31B, in which he requested authorization to provide the relevant state authority with the 2 other filings requested in its 4th March note verbal, which are confidential. So that now completes the procedural update. And I believe this is probably the best time to adjudicate the question I finished with, and that's the request by the registrar to provide the relevant state authority with 2 confidential submissions. The registrar cannot do that without authority of the bench. During yesterday's meeting with the parties, this issue was briefly discussed, and I was informed that neither party had any objection to providing the state authority with the 2 remaining confidential documents. Am I correct that these positions remain the same today? Ms. Begg?
Yes, Your Honor, I confirm.
And Maître Altit?
Monsieur le Président, pas d'objection.
Your Honor, no objection. Thank you.
Well, considering that neither party objects to providing the two confidential submissions, and considering that providing them will facilitate the implementation of the order for contribution, the request for authorization is granted. In granting this request, the trial chamber asks that the registrar inform the relevant state authority that these two confidential filings shall not be disclosed to anyone except to the relevant state authority or persons involved in this matter, and provided that the state authority obtains assurances from these persons that these filings and any information contained therein will remain confidential. So turning now to the question of provisional release. The trial chamber is very mindful of the fact that it has been approximately 18 months since the appeals chamber instructed the trial chamber to expeditiously consider matters related to Mr. Kabuga's release. The trial chamber has afforded Mr. Kabuga every opportunity and every avenue of assistance available to it to identify a state of release where he would like to go. To date, all three of his preferred options, which are located in Europe, have refused. The only state willing and obliged to accept him is his native country, Rwanda. However, he refuses to go there, and expert medical evidence suggests that it is not safe to transport him by air. This situation underscores the difficulties inherent in implementing the appeal chamber's instructions and explains why Mr. Kabuga remains in United Nations custody in The Hague. Notwithstanding these difficulties, we continue and we will continue vigorously to work towards a viable solution. Before addressing the most recent expert reports relevant to this issue, the trial chamber wishes to hear from the defence regarding whether there are any indications that progress is being made in identifying an appropriate and willing state for Mr. Kabuga's provisional release. While I prefer that we stay in public session to the extent possible and believe that it should be possible to discuss this in public session, we can, if necessary, go into private session to avoid disclosure of any sensitive and/or confidential information that you feel it is necessary to mention to me. I leave that to your discretion, Maître Altite.
Merci, Monsieur le Président.
Thank you very much, Your Honor.
Monsieur le Président, je vais commencer
Your
par
Honor, I will start
l'une des deux procédures. Et il y a
by talking about one of the two procedures.
des avancées.
Indeed, we have
Alors
made
cette
some
procédure, et nous sommes,
progress.
j'ai bien
So,
conscience
when it
que nous
comes to
sommes en
this,
audience publique,
to these proceedings,
concerne
well,
la France.
one of
Alors,
the countries is France, since we are
il conviendra
talking
rappeler
about it.
ici
So it is important to
que,
remember
que M. Kabuga a saisi le
that
tribunal administratif de
Mr.
Paris
Kabuga
et que le
addressed
16 septembre
the
2024, le
Administrative
tribunal
Tribunal
administratif de
of
Paris
Paris and
a
the
demandé au
tribunal, the
ministère des
Administrative
Affaires
Tribunal
étrangères
of Paris
français
had requested of the
de
Minister of
lui
Foreign
transmettre
Affairs of
un
France
mémoire
to
en
send
défense.
to
Le
him
ministère des Affaires
the
étrangères
memoir
disposait d'un
of
mois
the
pour le
defense.
faire.
They had
Il
1
ne l'a pas
month to
fait.
do so, but they have not done so. They have not sent that memoir.
Ensuite, le 20 février 2025,
On the
après
20th
que
of February
M.
2025,
Kabuga se soit inquiété de la
after
longueur de la
Mr.
procédure et du fait
Kabuga
que
was
personne
worried about the length of
ne
the
répondait au tribunal
proceedings and
administratif,
the fact that
le
nobody
20
was
février
replying from the
2025,
Administrative Tribunal on the 20th
le
of
tribunal
February
administratif
2025,
a mis en demeure le ministère des Affaires étrangères afin
asked
que le
the
ministère
Minister of Foreign
produise
Affairs, told
un mémoire
them,
en
ordered
défense.
them to produce a defense
Le ministère n'en a rien
memoir,
fait
and the ministry
et le 8 avril
did
2025, les
nothing,
parties
and on the 8th of
étaient informées
April
par le tribunal tribunal que l'instruction de l'affaire serait clôturée le 9 mai 2025, donc dans quelques jours. Après cette date, après le 9 mai 2025, le tribunal rendra sa décision. Cette décision peut prendre un certain temps pour être rendue et il est impossible aujourd'hui de donner à votre chambre un calendrier quelconque. Il est raisonnable de penser que la décision peut prendre 2, 3, peut-être un peu plus mois pour être rendue. Alors ensuite, je voudrais informer votre chambre d'avancée concernant la deuxième procédure. Et pour cette procédure-là, je souhaite passer en private session, en audience à huis clos partiel, s'il vous plaît, Monsieur le Président.
Just one moment before I decide on that.
Your Honor, the interpreters are hearing a lot of interference coming from the video conference side. Could the microphones be turned off, please? Thank you.
Yeah, I think that's a common experience here just now. So hopefully arrangements can be made to make sure that the microphones are switched off wherever there is no speech. And that would apply to anyone who's watching online and not actively participating at this point. At the moment, I've got an owl hooting in my ear from somewhere, every so often. And a lot of banging. So there's a microphone on somewhere that shouldn't be on. Well, hopefully this... It sounds as if the noise is coming from somewhere where someone is not concerning him or herself with proceedings, but is clearing out the family home. I'm frequently guilty of leaving microphones on and have to give special attention to it. So please, could anyone with a microphone available to them make sure it has been switched off? Right. Sounds better. Now, Maître Altit, you request private session. The reason for that?
Oui, Monsieur le Président.
Yes, of course, Your Honor. I have requested a private session because it was time to be able to speak publicly about the proceedings in France, because this seems to be an important step.
Comment dire, à une démarche de transparence qui est tout à fait nécessaire et utile. En ce qui concerne la deuxième procédure, je pense, et je vous l'expliquerai si vous le souhaitez, lorsque nous serons en huis clos partiel, je pense qu'il est encore un peu trop tôt pour en parler publiquement.
We're back in open session, Your Honor. Thank you.
Right. Thank you.
Your Honor, the prosecution appreciates very much that some of these matters take time. But in 20 months now, they have failed to yield any actual concrete results. So the only viable option at this point remains Rwanda. And I would submit, Your Honor, that the reasons for this are obvious ones. It is not just that Mr. Kabuga faces some of the most serious criminal charges, but for decades, he was also one of the world's most wanted fugitives. And he was living for many years in Europe under false identities supported by his family. And it is for these reasons, which are reasons of his own making, that it is exceedingly difficult to imagine how any European state or any other state would now grant him the kind of legal residency or accept responsibility for his release at this time.
Well, this, in my opinion, is not the moment for raising this form of submission where, as you know, the trial chamber as a whole has adopted the view that MICT-13-38, as long as he demonstrates he's doing what he can, should be given the opportunity to exhaust the domestic proceedings in these two countries upon which he has engaged. And it's unrealistic of you, I speaking for myself, but I would doubt if my colleagues would disagree, it's unrealistic to expect that at this hearing today, a decision is going to be made that will say, abandon your efforts and settle for Rwanda. That would be completely inconsistent with the approach that the bench has taken to what is a very difficult issue. So, bearing that view in mind, do you feel you want to pursue this line?
Your Honor, there does not need to be a one-track approach here. It is possible to continue to, as Your Honor put it, exhaust these domestic options while still making arrangements to move forward on the only viable option that sits on the table at the moment.
Well, as you heard me say, I was asking Mr. MICT-13-38 to update us on what was happening in relation to the issues, to the applications that he had made to European states before moving on to look at the more up-to-date position. I'm going to move on to Rwanda in context, but I assume the reason you're dealing with it at this stage is to ask me to do something about the ongoing attempts being made in France and one other European state. Now, I'm not going to do that, so I would suggest that you reserve what you have to say about Rwanda until we have looked at what I will identify as the issues that now arise in relation to that.
Thank you.
All right. Now, Maître-Altit, unless there's anything you want to say further on what you've already addressed me on, then I'm going to move on to the most recent reports.
Très bien, Monsieur le Président.
Thank you.
Fair enough. Mr.
Now, with respect to the recent expert report about air travel and fitness to travel by air, provided to the Chamber by Dr. Gert Moerling, as previously mentioned, the expert concluded that he could not declare Mr. Kabuga to be generally fit to fly. Furthermore, according to the expert, it's unlikely that Mr. Kabuga's health situation will get better in the near future, and flying him to Rwanda puts him at severe risk of medical deterioration. The medical expert further indicated that beyond the direct medical risks of flying someone in Mr. Kabuga's condition, there's a high chance of delayed negative effects of a long-range flight occurring within the first 10 days after flying. Notwithstanding the above, the expert provided a number of recommendations that might mitigate the risks to Mr. Kabuga's health should he or his designated guardian acting in his best interests wish to travel to another country. The expert explained, however, that these recommendations do not obviate his overall conclusions on the health risks to Mr. Kabuga. At this stage, there are now, including the one I've just referred to, 4 independent experts who recommend against Mr. Kabuga flying, including specifically to Rwanda. While the most recent expert may be best placed to assess the physical and medical impact on Mr. Kabuga travelling by air, he also points to the psychological impact of not having regular in-person family visits on his well-being, which would be relevant to his care on arrival when problems may manifest. This psychological aspect was similarly addressed by the panel of 3 court-appointed independent experts in their 5th and 6th monitoring reports. Now, these expert assessments are still under active consideration by the trial chamber. Further information and clarification may likely be required before determining the weight to place on these opinions in the context of deciding issues related to Mr. Kabuga's release. The chamber itself can see that there are questions that it would wish to address to Dr. Moerling for clarification of his report, and that should not necessarily be seen as his final word on the matter. So what I propose to do in that regard is hear what the parties have to say about what further inquiries ought to be addressed to Dr. Moerling for clarification of his report, and for any other submissions they want to make about the action the trial chamber should take at this particular stage, because we must accept that this is a process. It's not something that is going to be suddenly determined, and certainly not in the course of this hearing today. So I turn first of all to Ms. Begg for any further submissions you may wish to make on the lines I've indicated. And just for the avoidance of doubt, the things I've been alluding to that I see as obvious possible further lines of inquiry are whether a personal examination of Mr. Kabuga would assist Dr. Moorling in any way, and it may be it wouldn't. I mean, having reflected on that, I can see why it might be said it wouldn't. And similarly, his comments about facilities in Rwanda are generalized and based on apparently general statistical information or general reports of the situation in various parts of the world, resulting in a categorization of the health facilities in general, whereas what this tribunal is concerned about is the quality of what will actually be available to him should he move to there. So there are clear questions that we are aware of, and it's whether you wish to add to that list that particularly concerns me.
Thank you, Your Honor. On the in-person assessment, the prosecution would only note that with respect to all of the expert opinions, there have been some confounding factors of culture, of language, of communication. So if there were going to be a physical assessment or an in-person meeting, we would encourage Your Honors to set up some kind of briefing for the expert to be aware of that kind of situation and to facilitate the in-person meeting. With regard to the additional questions, I have 4 proposals for Your Honors, and some of it overlaps with what you have just pointed out. First of all, because his general assessment of fit to fly seems to be largely based on an opinion of flying in a commercial airliner, the prosecution would suggest that the chamber ask about specific recommendations for the parameters and condition of travel, including, for example, family accompaniment in an air ambulance situation. So there may be specific recommendations that could be made in relation to the safety of that kind of travel.
Is that not what's set out in the conclusion?
Your Honor, it is...
That envisages a voluntary journey and the various things that should be done to provide extra security for the person travelling. Is it that sort of thing you would wish him to expand upon?
Yes, Your Honor, but in the context of an air ambulance situation, you can see that the items 1 to 6 on page 4, some of those are addressed to different classes of travel on a normal commercial airliner. So an air ambulance situation would be one where there's a specialized aircraft that has inherently these necessary conditions, and what would be the parameters of that mode of travel that he would recommend?
Well, I'm prepared to consider that, but reading the list both now and before, I just can't imagine these arrangements being made in a commercial flight.
Your Honor, I point you, for example, to items 5 and 6, which refer specifically to business class compartment or a business class lie flat seat. And those items, to me, or to the prosecution, appear to be an assessment of a normal commercial airliner rather than an air ambulance situation.
I personally don't envisage any circumstances in which Mr. Kabuga would be flying in on a commercial flight. It may be a commercial plane, but it certainly wouldn't be a commercial flight. It's just out of the question. Anyway, you can propose what additional inquiry you consider should be made, and I'll make a note of it, and I'll discuss it with my colleagues before we decide what to do.
Your Honor, it's precisely for that reason, this conflation of, or the lack of specificity between a commercial airline situation and an air ambulance. It's precisely for that reason that we're suggesting a question or line of questions along that basis to clarify what parameters and conditions would be necessary for the air ambulance type of travel. And in a similar way, our second line of questioning would be about the medical services that the Fit to Fly expert envisages being needed in Rwanda. He has made recommendations that there be certain checkups at certain times, but it would be useful to know specifically what is required on arrival, both in terms of the medical checks that would be necessary and the services that might be required if a flight-related medical condition were to arise during that period of concern.
All right.
The third area is one that came up yesterday and that also arises in his comparison of the healthcare systems in general. The prosecution does not understand the chamber to have asked this particular expert for this type of general comparison, but if it were to be requested going forward, then it would be preferable for the expert to opine on what specific practices or procedures in his care regime the expert believes are not available in Kigali, in particular in the most advanced hospitals there, so that consideration could be given to determining whether those items of care or those medical treatments could be arranged in some other way. And finally, perhaps this is a theoretical matter, but some of the concerns in the Fit to Fly assessment seem to merge questions of whether it's in his best interest to travel, whether it's in his medical best interest to move from his current location. And in order to isolate the concerns about the safety of the flight from the concerns about the medical situation in the location on arrival, perhaps the expert could be asked to opine on whether fitness to fly in the other direction, hypothetically from Kigali to the Netherlands, whether that might allow him to isolate the fitness to fly on the flight portion of the concern. And I'm saying that because some of the considerations that the expert enters into are considerations that are inherent in him being moved out of his current familiar surroundings and being moved away from his children. And it's certainly the common view that moving him from familiar surroundings may have medical downsides or may not be the optimal treatment for his conditions. But any release to any country is going to require this type of disruption. And if they wish to do so, his adult children could certainly visit him in Rwanda or elsewhere. And unlike the situation in 2022, when the Chamber was concerned about moving him from familiar surroundings to Arusha, we're no longer looking at how to optimize the conditions of his care in the interests of a fair and expeditious hearing, because the proceedings have been indefinitely stayed. So the situation here is therefore different, and the legal considerations are different. And I can enter into that at a later stage, or I can continue now.
Well, it's obvious the circumstances are different, yeah. What can you add to that?
I can add that the concerns about moving him can't be the only reason to keep him in detention. Of course, he has to be treated humanely, like all other detainees, and he has to be treated in accordance with his fundamental rights. But, Your Honors, the defense have already complained to the President that his rights are being violated by his continued detention. So there is an immediate concern, and it shows that the status quo is not a viable long-term solution. He can't remain in detention indefinitely, so something needs to change.
Yeah, just give me a moment till I clarify something. Right, I now understand what you're referring to, yeah, please continue.
Yes, Your Honor, I'm referring to a 29 October 2024 decision of the President about the conditions of detention.
Yes.
Your Honors, it's the prosecution's position that while detention in Europe, closer to his children with the highest level of medical care and personal care paid for by the United Nations, maybe Kabuga's personal preference or his family's preference, this is neither the mandate nor the obligation of this institution. Because if he cannot stand trial, and if there cannot be an alternative findings procedure, then there needs to be clarity about the justification for his continued detention or a determination of where he should be released. And at this stage, Rwanda is the only country that's on the table.
Doesn't follow that he's got to go there, I'm afraid. It's got to be justifiable. And it's on that I would rather you concentrated.
I can certainly move to that, Your Honors. Your Honor, Rwanda has submitted before this chamber that they were ready, willing, and able to accept him on provisional release. It has committed to abide by the chamber's conditions, and it has informed the chamber that it has the high-quality medical facilities to care for him. And other detainees have been released to Rwanda successfully with extensive conditions and reporting regimes. And the ICTR has referred 8 cases for trial there, and the 3 who were transferred were successfully tried in accordance with international fair trial standards. And just last year, the mechanism demonstrated its institutional trust in the Rwandan medical system by handing over responsibility for the medical care of victims and witnesses to the Rwandan healthcare authorities.
This is not addressing, though, the issue of fitness to fly. All of that's a quite separate matter that this isn't the appropriate forum to go into. Rwanda will have their chance to make representations themselves as and when this issue arises, if they choose to do so. They've been told that before. But fitness to fly is what this is about, not an emotional plea to save the UN money. So try to concentrate on the issue of fitness to fly.
Well, on fitness to fly, the prosecution reads the current report as leaving open the possibility that he can be safely transported. And we would urge your honors to help the expert to tease out, with additional questions, what the real considerations are to make that flight safe and to make his arrival and handover to the Rwandan healthcare a safe and seamless one.
Now, and is that it on this point? Because I want to ask you another question. You're satisfied that it is within the power of this tribunal to grant provisional release and enforce provisional release against the will of an accused, are you?
Your honors have already determined that the defense has triggered, at least informally, the mechanism under Rule 68. And the prosecution submits that it is within the chamber's responsibility and authority, even if there is no formal request for provisional release. The chamber can obviously make a proprio motu determination of his release and the location of that release.
Are you aware of that ever happening in an international court or tribunal?
I am not aware of that ever happening. That is obviously not something that comes up very often. It is an unusual situation. I certainly admit that. But a person cannot choose to stay in custody. His liberty interests have been engaged by the defense already. His dignity interests have been engaged.
That submission I entirely understand, but it's a general submission that might apply in various parts of the world, but doesn't apply in the Netherlands, as you know. Nobody, no one who's an accused in the UNDU can be released onto Dutch territory. So we are in a different position from the domestic circumstances that you're envisaging.
Your Honor, I'm not suggesting at all that he be released onto Dutch territory or simply the doors be opened. The appeals chamber has ordered that his release be expeditiously addressed. There seems to be virtually no chance that any of these alternatives are going to be successful. I don't rule it out, of course, but the tribunal needs to begin to plan for his release, whether he has formally triggered Rule 68 or not. Now, of course, this is a matter that once you have decided in principle that he can go to Rwanda, then the parties and the registry and Rwanda and the Netherlands can all be heard about how to make the necessary arrangements. And the Rule 68 is, of course, subject to a right of appeal, so any decision will ultimately go up to the appeals chamber. So this is a legal process that's going to take some time, but it has to start somewhere. And the prosecution submits that it should start now with a general, in principle decision that absent any other alternative, realistic option, he should be transferred to his country of nationality. And I would point you to, for legal authority, for the chamber making this order absent a request by the defense. The terms of Rule 68 certainly allow for that.
Yeah, but I hear what you say about, and I appreciate your acknowledgement there are a number of issues here that may have to be determined. But if the question that I last addressed to you about whether he can be compelled to go to another country is answered in the negative, all of the rest of it's a waste of time.
But Your Honor,
you want to answer all the other questions first and then come back to the difficult fundamental one.
I'll come back to the fundamental question. We bring accused people to the Netherlands and we put them in custody very often involuntarily. And the corollary must also be true, that we can return them involuntarily.
But you have authority for, well, you indicated you don't know of it ever happening. In human rights cases, you may find the issue discussed. Repatriation would be the circumstance in which the issue would arise. But how relevant that is to our position would have to be demonstrated by whoever presents a submission. I just raise this as an issue you have to have in your mind, because if the answer to it is you can't do it, the rest of it is immaterial. However, that's not, again, that's like other things, not going to be decided today. I'm very grateful for the submissions that clearly indicates that much might be said on both sides of the argument of fitness to fly, but there are certain statements that in the report that indicate good cause for being very cautious about authorizing the movement of Mr. Kabuga by air between continents. And when the chamber has all the information that's relevant to the issue, it will be decided. For the moment, the question is how we gather that information. And I'm grateful to you for outlining the things that you think should be explored. And I'm sure that some of them, at least, if not all, will be taken up by the chamber in some form once we've considered the best way to go forward. Now, is there any other issue, any other point that you would suggest we should be exploring with Dr. Merling?
No, Your Honor, that concludes my points for Dr. Merling.
Okay. Thank you. Now, Maître Altit, do you have anything to say on this matter?
Merci, Monsieur le Président.
Thank you, Your Honor.
J'aurais beaucoup de choses à dire, mais je vais me cantonner à quelques brèves remarques. Et je crois que le meilleur moyen d'avancer, c'est de s'en tenir à ce que dit l'expert et de ne pas aller au-delà de ce qu'il dit. Comme ça, nous éviterons de le mésinterpréter. Alors, je voudrais notamment rebondir après que Madame le procureur ait dit que l'expert laissait la porte ouverte à un transport. La conclusion de l'expert est très claire. Félicien Kabuga ne peut être transporté au Rwanda. Un tel transport mettrait sa santé, donc sa vie, en danger. Il dit quoi? Page 3, l'expert
put
vais le
his life in
citer, mais en
danger,
français,
and the expert
page
says
3,
on page 3, and I will
le faire
quote him in
voyager par
French,
avion au Rwanda
the fact that he
l'exposerait,
should take the
il
plane to
parle de Félicien
Rwanda by
Kabuga, un
plane
risque grave
would
de
expose
détérioration de
Félicien
son état de
Kabuga
santé.
to a serious
Donc la question est réglée.
risk of the
L'expert
deterioration
explique que le
of
seul
his
voyage,
health.
même en
So
prenant
he's
toutes les précautions
explaining
possibles,
that
est dangereux.
this flight, the
Dangereux.
plane, this trip by plane would be
Il dit,
dangerous, even
par
if
exemple,
all the
page 4,
precautions
l'expert dit page 4,
would be taken. So the
outre, et je
expert says
cite
on page
en
4,
français,
and I quote
outre
in
les risques
French once
médicaux
again,
directs
aside from the direct
liés au
medical
transport aérien,
risks
les
linked
risques médicaux
to
directs,
the
ça veut dire que
transport by
s'il
air, so
voyage, il y a des
medical
risques médicaux.
medical
Quoi que l'on
risks,
fasse,
direct medical risks. So it means that if
je
he
vois une
takes the
forte
plane,
probabilité
there are
d'effets
risks.
négatifs
I
retardés
see
d'un vol
a
longue distance
big probability
sont les
of
effets négatifs qui survenant dans les 10 premiers jours suivant le vol. Donc non seulement il y a des effets, des risques médicaux directs, c'est ce qu'il nous dit, mais encore il y a des effets négatifs retardés. Et si vous regardez le début du rapport, vous comprenez très bien de quoi il s'agit parce que l'expert a pris la peine de nous expliquer et de nous expliquer quels étaient ces risques. Je ne rentrerai pas ici dans les détails, mais il nous a dit, par exemple page 3, qu'il y avait, non pas qu'il y aurait risque, mais que le fait, je cite simplement ce point-là, que M. Kabuga souffre d'une insuffisance rénale pourrait entraîner une diminution de la production d'urine et donc un œdème pulmonaire et une dyspnée. Et il précise que ce phénomène se produirait au Rwanda. Donc c'est très clair, les choses sont très très claires et c'est pourquoi la conclusion de l'expert est très claire. Pardon, oui.
Metraltit, we can read all this, and we know that there are lots of points in favour of an argument that it would be dangerous to fly him. You don't need to tell me or go through that in any more detail. I'm more concerned to know if you think that we should be making other inquiries of Dr. Merlin before we make a decision in due course on what ought to happen. Ms. Begg has outlined a number of things she thinks we should clarify with him, for example, or get more information about. I'm keen to know if there's anything you want us to explore.
Je vais vous répondre, Monsieur
Your Honor, I
le
will
Président, bien
answer
sûr,
to
si vous me
you
laissez une
clearly, yes,
seconde.
of course, but please allow me one
Je ne comprends pas
second.
ce que je suis en train de dire, c'est que je ne comprends pas. Je crois qu'il faut rester à ce que dit. Vous dites qu'il faut lire le rapport, et évidemment, vous avez raison. Mais où est la porte ouverte? Il n'y a pas de porte ouverte à d'éventuelles possibilités de transport dans ce rapport. À aucun moment, l'expert n'essaie de dire à telle condition qu'il serait possible qu'il n'y ait pas de risque. Il dit le contraire, l'expert. Il dit, voilà les risques, et si M. Kabuga, et seulement M. Kabuga, voulait prendre ces risques, sous-entendu, il considère que la Chambre ne peut pas prendre ces risques pour lui, parce qu'il va y avoir des conséquences nécessaires, des conséquences médicales très graves, nécessaires à l'issue de ce transport aérien. Mais il dit la chose suivante, si M. Kabuga veut lui prendre des risques, alors voilà tout ce qu'il faudrait faire pour mitiger ces risques. C'est ça qu'il dit. Mais il ne dit pas que cette mitigation des risques va réduire les risques. Il dit le contraire. Il dit il y aura les risques, il y aura les conséquences. Mais comme ce sera M. Kabuga qui décidera ce qu'il veut faire, c'est sa propre liberté. C'est son droit de prendre des risques aussi importants. Mais il le dit par honnêteté, parce qu'il a décidé d'examiner l'ensemble des hypothèses. Donc il examine cette hypothèse. Mais c'est une hypothèse qui concerne M. Kabuga. Ça ne nous concerne pas nous. Nous, ce qui nous concerne, c'est que les risques dont parle l'expert de manière très claire entraînent des conséquences nécessaires pour la santé de Félicien Kabuga qui peuvent être fatales, des conséquences fatales. Et évidemment, il n'est pas question de prendre ces risques-là. Donc, pardon, Monsieur le Président, mais juste je voudrais préciser, quand on parle de vol commercial, je ne sais pas de quoi on parle, puisque l'expert a dit, avec la meilleure volonté, en prenant les dispositions les plus lourdes, les risques seront toujours là. Donc, ne nous écartons pas de ce que dit l'expert. L'expert dit qu'ils ne prennent pas ce vol, sinon il y aura des conséquences qui pourraient être fatales. Voilà, ça c'est le point. Moi, la défense considère que le rapport est particulièrement clair.
Well, Maître Altit, there's a limit to how far you can go and ignore what I'm asking you to do. You're repeating yourself now, which is a very counterproductive thing to do. I want to know what you think the Chamber needs to do to find out or to clarify any of the issues that are being identified here. And you've heard what line the prosecution may take and what they want us to consider asking Dr. Merling about. Is there anything you want to say about questions that might be put to him?
Alors, compte tenu du fait que ce rapport est particulièrement clair de notre point de vue, nous considérons qu'il n'est nul besoin d'y revenir et de poser des questions auxquelles, de notre point de vue, le docteur Merling a déjà répondu par avance. Néanmoins, et donc la défense se remet à votre champ en ce qui concerne le contenu des questions, si question il devait y avoir. Pour ce qui concerne le détail des questions, nous nous contenterons de poser des questions sur la base, au Dr Merling, sur la base des questions qui auront été arrêtées par votre chambre. De demander des éclaircissements sur la base des questions qui auront été arrêtées par votre chambre. Mais nous n'avons pas de questions particulières à lui demander.
Thank you, Maître Altit. Now, it will be clear to both of you that that's not by any means the end of the matter, that should the Chamber decide that it wishes further information from Dr. Merling, there's every possibility that the form in which that information is being sought is in writing, and if so, that writing would be communicated to you in advance of it being sent to him. I can't guarantee that that's the course, but it would seem sensible at first blush on this instance, since you are so far apart on the views that you seek to present to us. So I can tell you that the Chamber will take these preliminary submissions into consideration during its forthcoming deliberation on this matter, and will tell parties the next steps that are going to be taken in due course. Now, there's an unusual matter I want to raise at this stage so that you do have time to consider it and the potential consequences. When the decision was made to stay the proceedings in September 2023, it was stated that status conferences would continue to be held every 120 days pursuant to Rule 69 until Mr. Kabuga is released from the United Nations Detention Unit. while I want to reiterate that these hearings remain an important tool for finding an expeditious solution to give effect to Mr. Kabuga's release, and that's plainly been demonstrated today, the trial chamber is also cognizant of the current budgetary constraints facing this institution. So the prosecution need have no concern that we are oblivious to the wider world as we look at the problems we face. These hearings must appear, at least to the outside world, as something that would not require extensive resources. However, that could not be further from the truth. In fact, these hearings, which usually only take about an hour, require planning and resource allocations amongst all branches of the mechanism and necessitate, amongst others, security arrangements, assistance from medical support staff at the detention unit, information technology support in this courtroom and the detention unit, and the use of court reporters, live transcription, and simultaneous translation. Considering the above, it would be remiss if the trial chamber did not consider the language in Security Council Resolution 2740, in which it is emphasized that in view of the substantially reduced nature of the residual functions, that the mechanism was established to be a small, temporary, and efficient structure whose functions and size will diminish over time, with a small number of staff commensurate with its reduced functions, and requested the mechanism to continue to be guided in its activities by these elements. Since the proceedings in this case are stayed, and since Mr. Kabuga remains in detention, while efforts continue to find a solution that would allow for his release, it's incumbent on the trial chamber to hold a status conference or hearing in some format to safeguard his fundamental rights. The trial chamber therefore considers that it is in the interests of judicial economy to start examining alternative arrangements in consultation with the registry and the parties. While the trial chamber examines this issue, in-court status conferences will continue to be held every 120 days in this case until such time as a further judicial order is issued amending that instruction. The trial chamber also wishes to acknowledge and thank the registrar and the staff of the registry for the tremendous efforts it made to ensure that today's status conference took place. That was no mean feat. So now to the last matter, but it's an important one, and that's the issue of Mr. Kabuga's health. Maître Altit, are there any observations you wish to make on that matter at this stage?
Merci, Monsieur le Président.
Thank you, Your Honor. No particular observations. Thank you.
And nothing in relation to the circumstances of his detention at present?
Monsieur Kabuga est fatigué, très fatigué.
Mr. Kabuga is very tired.
Mais je crois qu'il est suivi de la meilleure manière possible
et
que le staff médical fait tout son possible pour faire en sorte que les choses se passent bien. Il est difficile de dire plus aujourd'hui.
It is very difficult for me to say more today.
Thank you, Maître Altit. I'm assuming there's nothing the prosecution wants to say on that matter. So, in conclusion, let me say this. As Mr. Kabuga approaches 1.5 years in detention following the order indefinitely staying the proceedings, and despite the best efforts of the defence and the trial chamber, the prospect of Mr. Kabuga's provisional release appears, in the immediate future, appears bleak. While the Appeals Chamber acknowledged that release might be difficult, it may not have considered that the release of someone like Mr. Kabuga, who's been deemed unfit to stand trial for some of the most serious violations of international law, and whose health continues to deteriorate, might in fact be impossible, especially in light of the most recent expert report regarding his fitness to fly. As the trial chamber moves further into this year, it hopes to resolve the issue of Mr. Kabuga's fitness to travel and will continue its expeditious endeavour to find an appropriate solution to one of the most important issues presently facing this institution. On that note, please allow me to express my deepest appreciation to all of you who are with us today in the courtroom, as well as those who have moved on from the mechanism since we last met. I know I speak on behalf of the trial chamber when I say thank you to everyone at all levels of the mechanism for ensuring, even with the reduction of resources and during this challenging phase at the mechanism, that this status conference took place. The trial chamber is now adjourned.
All rise, veuillez vous lever.